Okay, so that takes us then to the black letter changes. And I think what we were going to do is break them down. So deal with the kind of Part 26, Part 26A differences, the moratorium provisions, and then perhaps bring in a bit of discussion about pre-packs, and then of course the wrongful trading points we've just been making. So if we start then with the Part 26 stroke, or as is the existing Companies Act scheme of arrangement provisions, and then the Part 26A, this new creature, what would you say, what reflections have you both got on the how those two procedures sit?
Well, of course, the Part 26 we've had for some time, but I think what's happened is that it has been used in recent years to achieve large corporate restructurings in a fairly successful way, perhaps limited to larger companies doing it. But it does have the deficiency that there's no ability to cram down creditors. In other words, to cause creditors who might not actually be affected by the result to not have a say in what is actually sought to be achieved. So that was seen as the major deficiency with the current Part 26 scheme arrangements. Under Part 26A, there is the ability to cram down creditors, and to do that in one of two ways. The first is if it can be shown that the particular creditor has no economic interest, as it were, in the outcome. And if that's the case, then they're sort of excluded from the voting process when one convenes the meetings of creditors. And the second is that when the vote is taken, if there's a class of creditors who votes against, and it can be demonstrated that they would be no worse off under the scheme as proposed than they would be under the alternative that would exist if the scheme had not been opposed, then that class of creditors can be ignored for the purposes of approving or otherwise the scheme. So there is this ability to cram down creditors, which does, I think, provide an alternative to the way in which there was a sort of de facto cramming down of creditors through the use of the pre-pack procedure under the old regime, whereby one would simply get the assets away by way of a sale to a new entity, and then the restructuring was carried out through the new entity, leaving creditors behind. So it could be said a more transparent process of achieving the same thing. So that's my sort of general reflection on the Part 26A scheme. Perhaps just add this, that I think the hope is that it will be used not just by large companies, but by small companies as well, or smaller companies as well, and certainly should be something that is there in the toolbox of companies, whether directors thinking about it as part of a restructuring process, or even administrators who are looking for a way out, or as a way out of a moratorium process. So think about it, I think, for smaller companies, and may well provide a more satisfactory alternative to the pre-pack.
Yeah, I mean, I think that the addition of the cross-class cram down really is the defining feature of the 26A schemes. I mean, in terms of terminology, the new practice statement on these that's been issued, I think means that courts are going to refer to them as either a Part 26 scheme or a Part 26A scheme, and the addition of that cross-class cram down is really the significant change, which again is perhaps draws inspiration from Chapter 11 type proceedings in the States. I mean, in terms of the real areas where the focus is going to be in getting these things through, I think that the work is going to be important. The work that's done around the alternative, in terms of whether a class can be crammed down. So are they any worse off than in the alternative scenario? Working on what that alternative scenario would realistically be, and what the outcome would be, is going to be really important, it seems to me, in terms of any when these things are argued before the courts, and in terms of where the areas of real contention are going to be, because of course the ability to demonstrate that a dissenting class of stakeholders would be no worse off in the alternative scenario is precisely what allows the court to approve a scheme notwithstanding the dissent of a whole class of stakeholders. That really is quite a significant feature of the 26A arrangements, and it seems that that's what seems to me where the work for IPs and lawyers is going to be in arguing these cases.
Well, I wonder if that point will introduce. It's an interesting point that makes me think about cost and whether or not that means that the aspiration for them to be used by small entities might be lost because of that cost. And then, and also I'm reminded of Paul Bannister's comment about usage in that R3 webinar, when he was asked about how many of these they thought might occur, and this was also a moratorium provisions, and he said roughly the same as administration now, as we now see it in the statistics. So do you think costs then might be an issue, or and what do you think about how often they might be used?
I think there are two issues. I think there is a cost issue and there is a timing issue, because of course you've got to go through the process of one court application to ask the court to give directions in relation to the convening of creditors and members meetings, and then secondly the court hearing which approves or otherwise the scheme. So there's the time aspect there, and there is the expense of obviously preparing all the documentation that's needed for that process. But it depends on the complexity of the company, doesn't it? If it's a relatively simple situation with a limited number of creditors and a limited number of lenders and so on, it might be quite easy to put together relatively quickly a Part 26A scheme, get it before the court, hold the meetings and get it approved. The big advantage, of course, going back to the alternative of the pre-pack, is that one can achieve the pre-pack very quickly, and therefore if a company simply doesn't have the cash to trade, the ability to trade at all, and that's the only option, then one can get the sale away very quickly. But I think in those cases where the company can carry on trading, it ought to provide a satisfactory alternative.
And I suppose that the difference there, as you highlight, Mark, with those two alternatives is the involvement in the court in the second one as regards the scheme. So, I mean, as you say, they're involved at the first stage in terms of safeguarding stakeholders' rights as regards the class composition, the convening of the meetings. But then ultimately, I mean, of course, the court would be very unlikely to refuse to follow the outcome of those meetings, but the court does have the absolute discretion as to whether to confirm the plan. Whereas, of course, one of the advantages and criticisms of pre-packing and administration is the fact of the lack of oversight and the lack of involvement of court scrutiny at that stage. So I suppose you've got those competing tensions, and it will depend on the facts of the case which one's appropriate. But I mean, in terms of the 26A schemes, the restructuring plan, my understanding from a policy point of view is that it's intended to be extremely flexible. And in terms of the purpose of the plan, it needs simply have the purpose of either eliminating, reducing, preventing, or mitigating the effect of the company's financial difficulties, whether they are actual in existence already or likely. If you remember a few moments ago, I referred to the financial condition and the company not having to be formally insolvent. So, I mean, that is a very broad, quite vague test that ought to be very simple to satisfy. So from that point of view, the restructuring plan doesn't actually need to be that complex if the circumstances of that company don't require it to be. Of course, it's going to be dependent on the financial setup, the securitization across the company, but it needn't be complex. As Mark says, you know, if one looks at how, you know, one might have proposed a company voluntary arrangement, one can easily see how you might adapt that into a scheme that could be utilised in this way for a more straightforward case.
And before we move into moratorium, perhaps both your reflections on how this new Part 26A scheme sits in the international landscape, the point Carly made earlier about viewing these reforms in an international sphere. What's your view on that?
Well, I mean, this is a step forward, it seems to me, for UK rescue culture. I think that previously one of the limitations of UK restructuring was the inability to cram down for dissenting stakeholders, so that a group of dissenting stakeholders could prevent the scheme from going ahead. I mean, in terms of the availability of it, it isn't only English companies that will be able to avail themselves. There needs to be a sufficient connection to the jurisdiction. Clearly, in terms of the formulation of the scheme and the legislation, that's drawn inspiration from, as I mentioned, Chapter 11 proceedings in the US. But also we need to have an eye to the restructuring procedures that are going to be introduced across Europe, and particularly under the European Insolvency regulation. Of course, one of the relevant factors to whether a court will approve a scheme is based around the general concept that a court won't make an order that has no purpose. So if a company is very international and the scheme is not going to be recognised in a sufficient number of jurisdictions in which that company operates, then that might be a reason why an English court might decline to approve a scheme. And from that point of view, it's relevant that it doesn't seem as though there'll be any automatic recognition of plans under the European insolvency regulation. So one of the things that practitioners are going to have to be prepared to persuade the court of on one of these schemes, to the extent that it's a non-English company with a variety of jurisdictions across the globe, is the utility of the approval of an English scheme, because, as I say, if it isn't going to be recognised by those different jurisdictions, that will limit the utility. Now, it seems at present that the test for that will simply be a matter of looking at the individual position under each of the countries in which the company operates, to see how they will view 26A schemes approved by English courts. So for the larger multinational corporations that avail themselves of this, that's kind of an extra layer of complexity and things to be considered alongside the other things we've mentioned already.
And what are your thoughts, Mark, on the sort of international, because I'm reminded of Viscount Trenchard in the House of Lords, where he mulled on us being 14th in the ranking. I always, the sort of language around how schemes, Part 26 schemes have been used in the past, that we're kind of like a front runner in these international restructuring things. But if we're 14th, that doesn't tally. What's your view on how?
There are so many criteria that come into play so far as that sort of ranking is concerned. But yeah, I mean, it certainly improves our position internationally, doesn't it, and provides another alternative for companies that fall within the definition of company, with its very wide definition in our legislation, to apply to the court to have a scheme approved.
Okay, that takes us to our next substantive area of consideration, and this new creature that we're seeing, the monitor who's operating with this moratorium procedure. So what are your reflections on how this moratorium might work? What are the problems, if any, that you envisage with the monitor and IPs, perhaps with conflicts of interest, or just general reflections on that?
I suppose the first point to note on the moratorium is that it is a very short period in terms of the initial period, so 20 business days. So I think that when people first heard about the moratorium and its utility in terms of breathing space for practitioners, one has to get on with whatever you are going to be proposing in terms of an outcome from the moratorium very quickly. Of course, we can no doubt consider that from a black letter perspective, the various ways in which the period can be extended. But yeah, I mean, the first observation I would make is that it is a holding the ring position. It's a very short period of time in which to propose a different outcome.
Mm-hmm. Because there is the provision to extend it, isn't it, with the approval of creditors and ultimately with the approval of the court. And I wonder whether it might not sort of morph into a sort of really an alternative to administration, and in many cases roll on for much longer than perhaps was initially intended.
I suppose that really will be and I can exactly see why. I suppose that really will be a test of the monitor in those cases, won't it? Because of course, as soon as the monitor forms a view that the rescue isn't going to be possible, they become under obligations to bring the moratorium to an end, and so I suppose it will test the robustness of the monitor as a role, something which of itself is relatively controversial. And I know that insolvency practitioners have been a little nervous about precisely what duties and obligations that role will entail.
I think creditors from whom the company has a payment holiday are going to have to watch the situation very carefully, aren't they? Because if new credit is racked up during the course of the moratorium, and that credit's going to get priority over what they might be owed, they've got to monitor it they've got to monitor it themselves very carefully, I think. And the monitor's role is, of course, very limited, really, isn't it? It's really just to verify from time to time that the statutory criteria is met.
I was on the sort of what we called earlier the calm Freund point about thinking about creditors as a stakeholder, and the length of time that they've already been kept out of their money, and then you've got this other set of delays for them that might occur. And then on the monitor, with your points earlier, both of you have made points about Chapter 11 and debtor in possession and wider influences. That I suppose this is the best example of that we'll have, in a certain sense, although schemes, of course, as well, we could argue of similar qualities, on the debtor in possession point, which then made me think about Elizabeth Warren's long-term collaborator, so now Senator Warren, but of course formerly a professor at Harvard of bankruptcy law. It's Teresa Sullivan and her work on debtor in possession, where she basically showed that basically the board is replaced pretty quickly. So it really isn't the same debtors in possession, it's a new group. So I was wondering if that might be the sort of thing that we see, or if the moratorium is much, much earlier than that kind of traditional sense of insolvency changes.
I suppose when the company goes to creditors to try and get the approval for the continuation, it's got to be able to sell its case and its position, hasn't it? And if there are criticisms of the existing board, then creditors can force the issue at that point, can't they? And effectively make any approval for the continuation of the moratorium conditional upon things being done.
Yeah. So on that, sorry, Carly.
No, I was just going to say, and that fits in with this idea of the monitor's role as being very limited, but that which they are required to certify effectively for any continuation, or indeed for the entry into the moratorium at first, it's quite a high threshold, and my view is that in practice, the standard might not be maintained quite as highly as it appears when one reads the provisions. And the reason I say that is, obviously, we're quite accustomed to what a proposed administrator must sign off on for an out-of-court administration appointment. And of course, because of the statutory purposes, it's relatively easy for an IP to sign off that one of those purposes may well be achieved. The criteria, though, of course, that a proposed monitor has to sign off on and has to remain satisfied of throughout the moratorium, is that in their view it's likely that the moratorium would result in the rescue of the company as a going concern, which is if taken literally, is a much, much higher standard, and it's effectively signing off on a ground A statutory purpose under administration, and I can't see for moratoriums to work how strictly and how much evidence they will require to sign off on that, because I just can't see otherwise how IPs will sign off on it.
Yeah, I'm not entirely sure about that, because I mean the likely test is I think if one gets back to the cases on administration, is not more likely than not. It's a real prospect of achieving. Yeah. So that's not a necessarily particularly high test to follow. And then rescue of the company, of course, one's entitled to bear in mind how the company could now be rescued. And one of the ways the company could now be rescued is through a Part 26A scheme.
Yeah.
So if there is a realistic prospect of being able to propose a Part 26A scheme, then that would provide a ground on which an IP could sign off as monitor to approve it going forward. So it is rescue of the company in the new sense of potentially through a Part 26A scheme.
Yeah. Yeah, I suppose that what it can't just be doing, what it can't be used as is is to hold the ring for something other than a rescue. So a more traditional administration where you're looking at a purpose B or C, one can't, I mean, of course there are other there's an interim moratorium that's available there anyway, but it's it will be
just a traditional CVA as well. If there's a realistic prospect of a CVA being approved, which might well be the case, then yeah.
Okay, that takes us to our third substantive area, but of course a temporary change, and that's the wrongful trading relaxation. We've already mentioned, Mark's talked about the balance of changes in 86 with the introduction of wrongful trading because of the issues with fraudulent trading, and then the disqualification provisions, so forth. There's that check and balance against the abuse of limited liability or the unfit use of limited liability models. And of course, indeed, members of your chambers of exchange have written about the relaxation of wrongful trading against the backdrop of we might even call it a smorgasbord of other provisions. So 174 being the very same words apart from one word in terms of a general duty of negligence-based duties of objective and subjective competence that we can think about. So what are both your reflections on the relaxation of the wrongful trading provisions, how that sits against the broader backdrop of other director duties and obligations, and how this generally fits in the kind of our understanding of that balancing point that Mark made earlier with the 86 Act?
My own view is that I'm not sure that it makes that big a difference in the way that it has been enacted on this temporary basis and only limited to the wrongful trading provisions to the formal scope of the liability of directors, because as you've alluded to, the full gamut of directors' duties are still owed. In the zone of insolvency, there is still the obligation to take account of creditors' interests, and of course there's still all the liabilities that exist under fraudulent trading, misfeasance and transactions defrauding creditors. I suppose what it does do is send a signal to office holders, directors, lawyers, as to perhaps how the court might view those sorts of claims if they arise out of conduct during a period in which the government has sought to send this signal of relaxing the wrongful trading rules. So, so I certainly think that if I was analysing a director's duties case that arose out of a director's response during this COVID crisis, it would factor into my thinking, even under the other duties, that there was this relaxation under wrongful trading, and how the court, from a subjective point of view, might view the conduct. It of course doesn't change the formal scope of the liability, but I think it sends a signal.
It is just a temporary provision, and it is sort of COVID related, isn't it? So it's any worsening of the company's condition essentially against the background of COVID, which is excused. I think so. The interesting thing about Section 214 and wrongful trading is that one rarely sees a successful case being pursued of wrongful trading and a judgment actually being obtained. But having said that, it sort of sets a standard which I think directors are obliged to and will consciously, in most cases, work to. And that's why I think it's been relatively successful as a piece of legislation, although it's not actually been successful in the sense of resulting in many claims. And so I think the fact that it is there, that it's a fairly sort of limited, that there's a sort of limited exception, and that there is all the other statutory provisions remain in force. I think it's ultimately fairly neutral in the consideration of the balance between creditors and debtors.
Yeah, I think when it is operational, as Mark says, it almost operates as the trigger to force the directors to go and get advice when they're heading towards an insolvent situation, because there's nothing like the theoretical prospect of personal liability for the company's debts to perhaps make one sit up and consult an insolvency practitioner. So I think that is, as Mark has identified, that really has been perhaps its greatest achievement. As it says, it's quite rare to see a successful case. They are almost always pleaded on a misfeasance basis or a general director's duties basis, or the other anti-avoidance type claims that you'd see following an insolvency. So I think its practical impact will be quite limited, actually.
Yeah, I was wondering on your point about a kind of psychological message to directors, if it was confusing because of the backdrop points, but then I suppose actually with your answers, both of your answers, it might have done the opposite in awareness raising. So if we could argue that previously directors haven't been as au fait with their duties as they should have been, perhaps this has made them focus more, or might make them focus more on what duties they owe in both an insolvent and a non-insolvent environment. So we've briefly touched on pre-packs. I just wanted your reflections really on how you see pre-packs. So Mark talked about the legislative process and how there was some reflection again on them, but how you envisage pre-packs sitting in this new environment. So within moratoria, Part 26A, or just general usage now. What are your reflections on pre-packs going forward?
I think I go back to the point that there probably is still the need for the pre-pack in the situation where there is simply not the funding available to continue trading, and one can achieve a better realisation of the assets through administration than one can by way of liquidation for whatever reason. And so I think that they will continue to that extent. I'd like to think that pre-packs or sales out of administration can be replaced by Part 26A schemes in a more sort of regulated and open process through Part 26A schemes. But I'm not that necessarily hopeful that's going to be achieved. And I never thought I'd say this because it's always been my sort of contrary view, but I think the case for regulating pre-packs has increased and can be justified rather more against the background of the new regime. I can see at the moment, whilst the coronavirus crisis is in full floor, you wouldn't want to be restricting pre-packs because it provides additional flexibility. But I think once we've got beyond coronavirus and we've got these new regimes in place, I think there is a case for revisiting regulation of pre-packs and a serious case for requiring reference of all pre-packs to the pre-pack panel.
I think that pre-packs have always been controversial, haven't they? And I think what one needs to carefully look at with pre-packs is if pre-packs themselves are inherently objectionable, or the way they're being used is inherently objectionable, or whether it's really a perception that something dodgy is going on because of the lack of transparency, because very often it's only the people involved that are aware of it until after the event. And so that, I think, is what quite often kind of engenders this sense of this sense of that there is something more to it, there's something there. Whereas very often the pre-pack sale is the only realistic sale that is likely of those assets. So it's an unusual case where you could either, even with hindsight, look back and say, well, there were all these other viable sale options that were available that have been ignored. So I suppose that, and this is a much wider debate about pre-packs and how we deal with them as an industry. But I suppose the first thing that could be done to address it is to look more at transparency of pre-packs as a first step towards more regulation of them. because I think as well, one of the concerns is that you might have, for instance, trade creditors who go on trading with a company right up until it then goes into admin for a pre-pack, and have been doing so without any knowledge of all these things going on in the background, and they feel they're the ones left out that have continued to extend the credit, etc. And so it might be interesting to see to what extent a freestanding moratorium, which is used perhaps even prior to the usual moratorium that you might have had in an administration, if other options being considered as well, might affect that, because of course within one of those there is the entitlement for ongoing payments, etc., for ongoing trade and supplies to the company during that period. So I think we just have to be careful with pre-packs, because I think that they are a really important tool in the overall options that are available. And I think that whilst we do hope that these schemes will be available to the smaller companies, in reality it may be that as a regime they end up being a little too complex for some of those companies, and that for smaller businesses a pre-pack is the best option and best outcome for creditors. So I think we need to think about them in that context, really.
I think both of you have used the word transparency, and it was making me think that would be a good lens through which to write about both at Part 26A in the way that Mark's explained in this new transparent sense, but then also reflecting back on how pre-packs have been used, the pre-pack pool, etc., and Sandra Frisby's work, and just general movement over time of transparency. So how has transparency changed? But perhaps that's something we can keep an eye on.
I just come back on one point on that. I mean, I think something that's made a difference on transparency is the ability to make an out-of-court appointment of administrators. Prior to the Enterprise Act 2002, you had to go to court to get your administration order and persuade the court that one of the purposes of administration could be achieved. And if you were proposing a pre-pack, you'd essentially have to tell the court what you were proposing to do. And the court, the authorities indicated the courts were not supposed to interfere and make their own commercial judgment against the administrator's judgment, but at least it allowed it to be ventilated in a sort of open way. But with the out-of-court appointment, you get the out-of-court appointment of potentially, in some cases, the out-of-court appointment of the insolvency practitioner who's known to the companies, have been advising them for a while, stitched up a sale to management in circumstances where it appears there's no other option, but who frankly knows. And we've all seen cases where management have bought and the second company has been a failure because there's never the ability to pay the consideration under the contract that was entered into the pre-pack sale.
It's exactly that scenario which has given pre-packs the reputation that they have had, because the other creditors learn of it is after the event. Whereas, as Mark says, but prior, when one only had in-court appointments, there was at least the opportunity for scrutiny of the court and potentially other creditors to be involved if they wished to pass comment. So,
okay, so we're breaking up our treatment into 6 areas.